Welcome, everyone. Thanks so much for joining us today. We're really excited to present this topic to you. Our topic today is navigating the pathway to maintaining PBM network compliance. My name is Harini Bupathi. I'm one of the partners here at Frier Levitt, and I'm joined by my colleague, Knowles, who's also a partner at Frier Levitt. A few quick housekeeping items. We just always want to remind everyone that this presentation is purely for informational purposes. We ask that you don't construe anything that we say during this presentation as legal advice. So my name is Harini Bupathi, like I mentioned. I'm one of the partners here in Frier Levitt's Life Sciences Group, specifically what we call the Pharmacy Practice Group. My focus is on counseling pharmacy providers, whether that's independent, retail, specialty, mail order, physician dispensing practices, any sort of provider type on their relationships with PBMs on a range of issues, whether that's audits, terminations, network access issues, investigations are obviously included in that, et cetera. I also advise providers on transaction-related issues such as like change of ownership considerations when going through, buy and sell of a pharmacy, et cetera, and then licensing and credentialing when it comes to payors as well. And so there's a lot of intersection between that. And so really, when it comes to PBMs, almost like the A to Z in our practice group here.
And hey, everyone, my name is Knowles. I'm a partner here at Frier Levitt. My focus is on life sciences litigation. I work closely with Harini and the PBM audit team. My focus is when, let's say, a dispute gets to the point where we need a neutral third party to make a decision. That's when I step in, whether it be arbitration or court. And a large part of my practice is focused on PBM terminations. So welcome, everyone.
Just a little bit about Frier Levitt. I know obviously a lot of you guys know who Frier Levitt is as you guys have joined the webinar, but we are a national healthcare and life sciences boutique law firm. Both Eric and I are on our life sciences side, and so we do work with a lot of life science providers, again, pharmacies in particular. That said, we do have a very diverse practice groups here at Frier Levitt, including transactional team, litigation team, regulatory team, and investigations team. Again, when it comes to the sort of the A to Z to pharmacies, we're certainly a legal support for folks. And then of course that translates well into our healthcare side as well. And so our presentation today is certainly focused on a couple of things. And in the past, a lot of our presentations have certainly been a lot more PBM audit focused and making sure that pharmacies understand what key audit topics they should be keeping an eye out for as they go into every year. And the reason that we decided to do this specific topic of maintaining network compliance is to make sure that there's an understanding that, yes, audits are a big part of making sure pharmacies overcome or maintain their PBM network status, but also understanding the repercussions of not addressing those audits, and then generally on how to maintain network compliance. And so the biggest thing is for us to understand what kind of pitfalls a lot of pharmacies have based on what we see as PBM trends, whether that's audit trends or just general network trends, or just different kind of methods that we've seen PBMs kind of use to weed out pharmacies. The other thing that we'll be doing is understanding what contractual and legal avenues you'll have to be able to challenge adverse network actions. There's, of course, contractual obligations that you have, or contractual avenues that you have, but beyond that, what else can a pharmacy do to be able to challenge network actions? We'll also go through a couple of examples that we've seen just in working with pharmacies through these types of issues in the past. Like Eric said, he's usually handling a matter when it reaches to that point of litigation, and I'm usually handling it up until that point and hopefully not having to escalate it there. And so you'll certainly see both sides of that. And then the other thing is, as we kind of go through this, is we hope that you'll take away an understanding of how you can protect your own pharmacy to make sure that you're maintaining your PBM network status as you go into 2026, and then of course for years to come. The other thing I'll just mention is I know we indicated this was a tabled-side chat, and so while Eric and I are at our respective tables, we really do hope for this to be a conversation about some of these issues, and so you'll certainly see that happening throughout this presentation. The PowerPoint slides are certainly for, of course, information, and we hope that it's a great resource. We do hope that you participate through the Q&A and feel free to ask any questions throughout.
Yeah, all right. Thanks, Harini. So one of the topics that we want to discuss are PBM network participation pitfalls. So Harini, in your experience, all right, the pharmacy gets their audit results, right? So what are the main reasons pharmacies must resolve audit findings, even if the recoupment doesn't seem so bad? Let's call it small. I know it's hard to call things small when it might even be $1,000, but why should a pharmacy try to resolve those audit findings?
Yeah, and it's a couple things. $1,000 is small, but depending on the types of discrepancies, those audit findings might not necessarily be small. And so a lot of the times what we'll see is folks decide, okay, it's just $1,000, $5,000. It's not worth our pharmacy's resources in trying to challenge those audit results. But the problem is that audit results, depending on the type of discrepancies, and we'll go into that, could be the reason why a termination gets triggered of the pharmacy. So beyond the monetary aspect of the audit itself, which I always am of the position that if you dispense the medication, you purchased it properly, and then you dispense it to the patient, they receive the benefit of it, there shouldn't be otherwise a chargeback, especially for not an issue of like a clerical error or like a typographical error. Those I think are the most concerning ways that PBMs otherwise claw back money on. But besides the monetary aspect of it, a lot of the times, depending on the discrepancies, PBMs could decide to terminate pharmacies over them, even if the audit amount is small. So that one audit could certainly lead to the termination, but oftentimes what happens is that PBMs decide to compound audits as well, right? So while this audit might have been $5,000 or $1,000, the one before that could have been $2,000. But if there is a repetitive pattern of having audits that continue and that there's discrepancies against the pharmacy, that certainly leads to PBMs considering whether or not they want to keep the pharmacy network. The other reason is because some folks decide, okay, I paid off the amount, nothing happened to me. Nothing's going to happen to me because it's been a couple months. Oh, it's fine. But then the pharmacy owner decides to go ahead and open up another location. And when that happens, PBMs decide to look at how that pharmacy owner's other pharmacies participated and performed in their networks. And then they see that there's outstanding audit results or that there were audit results that had even some monies associated with them, just that the fact that discrepancies were outstanding, and then decide to deny that new pharmacy network access. And so we often see that happen. And so not only should pharmacies resolve audit findings for the purposes of securing their own network status, but also in the event that, should they ever find themselves in a position to have to either re-credential or credential a new pharmacy, that they're putting their best foot forward.
Pretty. What appeal and dispute procedures should pharmacies be prepared to fully exhaust to prevent, let's call it, further disciplinary action? And are they different based on the PBM they're dealing with or the state the pharmacy is located in? Do those things matter?
Absolutely. So every PBM has a provider agreement or a provider manual for the most part. Whether it's an agreement and a manual or an agreement or a manual, most every PBM has those. And so pharmacies should certainly understand what obligations they have in responding to audits, but also what rights they have to be able to challenge audit results once they receive any results as well. Depending on the PBM, there might be instances of where a pharmacy can only respond or appeal initial results. Depending on, again, the PBM, there might be instances of where a pharmacy can appeal final results, which is really important because a lot of the times when you receive final results, you usually think that's the end of it. That's not true. In like 99.9% of the cases that we see is that they're not final. And I say that because pharmacies have the ability and the contractual ability, but also the legal ability to be able to challenge those final results. Some PBMs expressly allow you to appeal final results further, while they they kind of hide it in their agreements where they suggest you can further dispute them or dispute any issues. And we certainly take advantage of those types of provisions and those provider agreements and manuals to be able to further challenge audit results. So when a pharmacy receives final results, no pharmacy should really take it at face value and consider those results to be final. And I always like to say this is like, you wouldn't want the PBM to have the last word really in any aspect. And so it's really important for pharmacies to make sure that they're making their position clear, whether it's $1,000 or it's $100,000. I always think that it's really important for our pharmacies to challenge audit results. But again, also understand what appeal rights you have and then dispute rights as well. And we'll go into sort of what dispute provisions even mean. But generally, dispute provisions are in your agreement and kind of indicate that if you have an issue, you have the right to dispute or, bring up an issue to the PBM, and that there's a contractual obligation to engage in that discussion. So basically, when you see final results, don't consider them to be final.
All right. So we're talking about audits, right? But sometimes PBMs call these investigations, right? And they're very particular. So if
Yeah.
you say, oh, this particular audit, they have a tendency to correct us and say this is an investigation. So, Harini, do you feel like audits and investigations are treated the same by a PBM, or how would you
Yeah.
describe that?
Yeah, and that's I will say that for some PBMs, they only call their audits investigations. So they look and like they smell like an audit, but they're still called investigations. And they're not treated the same, right? They're investigations, I'll say, are much more aggressive in terms of the line of questioning that PBMs have, but also in terms of the documentation requirements that PBMs have as well. For example, where an audit might otherwise give a pharmacy 30 days to be able to respond to an initial audit, like initial result. An investigation might only give a pharmacy 14 days to submit an appeal of the investigation results instead. So PBMs definitely treat investigations much more aggressively. And I will say there's a PBM I can think of in particular where it's been like what 9 years that I've been here, right? And I'll say that I haven't seen an audit from them or someone raise an issue of an audit from this PBM in about 8 or 9 of those years. And everything that we see from this PBM is called an investigation. And by calling it an investigation, this PBM is able to say, you need to give us the documents within 2 weeks. You only get 2 weeks to respond to the initial results. If you got final results, then you'll probably get terminated if you have final results because you have discrepancies. If they're minor, you'll get hit with a warning letter. But if they're anything significant, again, dollar value, dollar amount assigned, you may face termination. And so different PBMs do use the word investigations. And even more recently, we're seeing the word investigative audits be thrown around, right? Which is concerning because it's like, is it an investigation or is it an audit? And one of the reasons why PBMs do this is because they know there's fair audit laws out there. And I will say, and Eric, correct me if I'm wrong, right? Most fair audit laws have an exception for FWA, meaning that these laws apply to an audit unless the PBM suspects FWA. And by calling something an investigative audit and by calling something an investigation, they just circumvented fair audit laws and kind of all the rights for pharmacies. They think that, get thrown out the window. So, PBMs have been starting to call a lot more things investigations, more and more, and they definitely, I will say, are not treated the same.
No, I can't agree with you more, Harini. Um, so call it investigation audit, whatever you want to call it. I like to call it an audit, but
We call it an
PBMs,
audit just because it's all encompassing, right?
yeah. But are there discrepancies that can automatically trigger a termination if left unresolved in your experience?
I don't want to say automatically, but based on the
Okay.
PBM and depending on the amount at issue and the types of discrepancies, we can kind of gauge at this point whether or not we think a PBM is leaning towards a termination of the pharmacy. So I always am of the mindset, based on our experience and what we see PBMs usually trigger terminations are over, is that there are certain discrepancies that not necessarily automatically trigger termination, but could certainly trigger termination. The biggest thing out of all of those, and actually I'll just name them really quickly. They're inventory shortages, member denials, and with member denials, I'll divide that by member denials of denied requesting and denied receiving. There should also be prescriber denials thrown in there. We don't see it as much, and it's a little bit easier to overcome, but still an issue. And then copayment discrepancies. I'll say that those are, what is that? Like, I guess like the 4.5 really types of discrepancies that I always think that should certainly be addressed. And then, of course, if you have any combination of those, that's also sort of another issue as well. Inventory shortages, I'll say, however many times we've done a lot of as many proactive measures as we can in sort of educating a lot of pharmacies on sort of how to maintain inventory management, best inventory management practices, we will still see inventory shortage discrepancies in almost every other audit or investigation that we deal with. And it's not so much that pharmacies aren't doing a good job of maintaining their records of demonstrating they have sufficient inventory. It's so much more about PBMs just not willing to accept those purchases, right? And so by not accepting those purchases, they're suggesting that the pharmacy has inventory shortages. So it's not just an instance of where in a calendar year you purchased 100 tablets and then you build and you dispensed 120, meaning that you have a shortage of 20 tablets. It's so much more about the year before that you made purchases that would have supported your purchases going into the next year, or your dispensing into the next year, and maybe you didn't maintain the documentation related to it, or maybe it was so far outside of the audit period at issue that the PBM's not willing to accept it, or it's from a wholesaler or that's not otherwise accredited or doesn't have the accreditation that's required, or maybe it's also from a marketplace that the pharmacy didn't demonstrate that they maintain sufficient documentation for. And so there's a number of different reasons as to why inventory shortage discrepancies could be alleged, and how those types of discrepancies could certainly lead to termination. So when I talk about like inventory shortages, when it comes to bulk purchases, it's interesting because a lot of PBMs suggest we won't accept purchases if they're a month out prior to the audit period or 3 months out prior to the audit period. It doesn't make any sense because the pharmacy is going to continue purchasing, and especially if they have a pricing advantage, to take advantage of a better offer to make sure that if they know they're going to dispense it, they might as well keep it on their inventory. And it's interesting because now we're seeing where some PBMs have those bulk purchase notification requirements, where pharmacies have actually made those notifications. And then the PBM said, oh, we don't consider this to be a bulk purchase. And now months later, the pharmacy is still being hit with an audit over those same notifications they tried to make, and the PBM had denied it because they said it wasn't a bulk purchase. So it's kind of been a very weird situation of where the PBM is saying you need to notify as a bulk purchases, and then denying accepting those notifications, and then auditing the pharmacy anyway for it. So that again, that's why a lot of inventory shortages happen, is because PBMs are just not willing to accept a pharmacy's purchases. The other thing, like I mentioned, are marketplace purchases, or like purchases from unlicensed wholesalers, or not unlicensed, but non-accredited wholesalers, I should say, is that PBMs expect that pharmacies maintain a lot more documentation for those, right? And so that could be pedigree documentation, it could be a copy of the invoice from the pharmacy that they purchased it from, et cetera. And in the situation where a pharmacy doesn't have that, the pharmacy is being asked to they're being asked to demonstrate that the documentation or the purchase was for a specific patient need, meaning that they purchased that specific medication from a marketplace where they were connected to another pharmacy because they had a prescription in hand, and then they had made that purchase to be able to service that specific patient and for specific patient need. And that's like the documentation exception. And so we're seeing a lot around inventory shortages in just different forms. And that just continues always.
Yeah, thanks for your insight on inventory shortages, Harini. Just going to these member denials, right? Like when when members deny requesting or receiving prescriptions, what documentation resolves those findings in your experience?
Yeah, it's interesting because, like, if you think about why member denials even happen, it's because usually in the course of an audit or an investigation or an investigative audit, PBMs are sending out these questionnaires to patients. Did you request these medications? Did you receive these medications? And then if they, for some reason, even like indicate like the wrong answer on even a small part of it, of like, no, I didn't get. Um, like I got this medication, but I got it on a different day or something else like that. It's almost becoming like a member denial automatically by the PBM. Um, the biggest thing that a pharmacy, like the best documentation that they can try to obtain, is certainly an attestation from the patient to suggest that their previous attestation to the PBM wasn't otherwise accurate and that they did, in fact, either request or receive their medication. It's almost like a timeline, unfortunately, right? It's like, yes, when you got the prescription, you confirmed the patient wanted it, you dispensed it, great. But then at some point thereafter, the PBM reached out to the patient and the patient said, no, that's not true. And then now you're being asked in that timeline progression to then go back to the patient and then say, hey, don't you remember you got this medication a year ago? I know you're being asked about this a year ago, and try to, again, remind or be able to go through that with the patient to then get documentation to submit to the PBM. And I say attestations are certainly the best form, again, for like that timeline aspect of it, so that PBMs are unfortunately a bit more convinced. But realistically, what should help is certainly the documentation leading up to the dispensing of the medication, right? For example, if a patient paid their copay, but then denied requesting their medication, that just doesn't add up, right? Like, why would a patient pay for their copay and deny requesting the medication to the PBM when asked about it? So while attestations would certainly help, there are certainly other forms of documentation that we would use in the appeal process and the dispute process to suggest that, the patient did in fact request and receive their medication, at the point that you actually dispensed it maybe a year before they were being asked about it.
Okay. And for copay collections, what proofs do PBMs expect to show that a copay was actually collected?
Yeah, and we're seeing a lot more an increase in like the documentation that's being asked of pharmacies to maintain this. And it's so tedious, and this has been going on for about, like, I'd say it's like our second year, maybe third even. And a lot of pharmacies continue to get surprised by it, only because there are so much more aggressive documentation requirements. So even though a pharmacy may have a register receipt with the four digits of the patient's credit card number and like all the prescription information, it's not uncommon for a PBM to ask for the pharmacy's merchant report, meaning their credit card processor's report that demonstrate that exact line item to show that the patient did in fact use their credit card and the pharmacy did in fact receive payment. And it is such an extra step for pharmacies to go through this, but it is becoming common for them to be asked this information. And the same thing with patients who pay their copays in cash. PBMs expect that if patients are paying in cash, that the pharmacy is making regular deposits into their bank accounts as well. And sometimes, and it's not uncommon, for a PBM to say, show us, the corresponding deposit into your bank account for these cash copays. And so we're seeing that increase in documentation requirements for copayments. And so for that reason, it's really important for pharmacies to have copay collection policies as well as financial hardship policies. There's some PBMs out there that actually identify exactly what needs to go into a financial hardship policy as well, down to like the exact sort of communication you need to send to patients about their qualification for financial hardship, and how often they'll get reviewed, and then even how much they'll qualify for financial hardship, et cetera. So it's really important for pharmacies to certainly have copay collection and financial hardship discrepancies. The other things I'll say, in addition to these 4.5 discrepancies, the other issues that we'll see are like prior authorization discrepancies continue to be a big thing, right? So if any pharmacy ever has involvement in the aspect of PAs, they should certainly make sure they're being submitted in accordance to their PBM terms and conditions.
Right. We touched on this a little bit, but as far as recurring issues and noncompliance with certain notices, um, I believe there's a slide before this one.
Yeah, no, we did talk about this one, right? Is the
Yeah.
fact that a lot of times PBMs do compound audits, right? Is like if they see a pattern of the same issue occurring over and over again, audit after audit, they certainly use that as a means of reviewing the pharmacy. So it's not uncommon, well, one audit, it might seem like be the reason why you might be up for network review. In that notice, it might say like, hey, this audit in and I've seen them go back sometimes. Some PBMs go back as far as like 6, 7 years, 8 years even. And they'd be like, this audit from 2016, plus the audit in 2020, plus the audit in 2025 that just occurred, is the reason that you're being presented to the network for review, right? And so it's not just like the same types of discrepancies, but just the fact that you have audits that continue to have discrepancies, however minor, again, $1,000, $2,000, doesn't matter. They'll do the kitchen sink approach for sure, and they'll throw it all in there to make it seem like you have a pattern of non-compliance. Right? So it's really important to try to resolve as many of those discrepancies as possible so that PBMs can avoid having that doing that compound review of a pharmacy.
And so how does failing to comply with like corrective action requests, say, or cease and desist notices impact termination risk?
Yeah, so like I said, when you have compounded results, that certainly increases the risk of a network review or termination. But when you have an audit and you, for example, had discrepancies, and the PDN says, okay, instead of terminating you, we're just going to place you on a corrective action plan, or we're just going to send you a cease and desist notice and ask that you refrain from engaging in that conduct going forward. If that happens, and then a pharmacy were to continue with that conduct, right? Whether that means they continue to not comply with that cease and desist, or they don't comply with their own cap, right, that they were placed under. For example, if the cap was for like you're going to make sure you submit the correct NDC at claim submission, but then you have another audit and then you fail to put the right NDC again, PBMs love to throw that back in your face and say you didn't comply with with the cap that you agreed to the last time you were audited. Same thing. We sent you a cease and desist. You agreed that you'll stop engaging in that prohibited activity, yet you still continued. And so not only will they then try to terminate you on the current reason of like the audit you're facing, they'll also say, also you failed to comply with the cap from 2021. You failed to comply with the cease and desist from just last year, right? And so again, the kitchen sink approach, especially if they see like the same conduct happening, they'll be more than happy to point that out.
Okay. And can you give an example of conduct PBMs often warn about? Like we see mailing prescriptions as an example, and so it's just kind of how that plays out.
Yeah, yeah. Mailing cease and desist notice, especially over like mailing, is very common. We'll see certain PBMs send out cease and desist over mailing, especially now that like the PHE expired and the mailing limitations are back in place. We'll see a lot more cease and desist notice over that. And so if a pharmacy receives a cease and desist, they say, okay, we're going to cease mailing. Gets hit with an audit and they continue mailing. Not only are those claims going to be subject to a full chargeback, they'll also lead a pharmacy to probably getting terminated from the network. And I'll point out that, like, again, when you have mailing prescription discrepancies and then couple that with member denial discrepancies, that's almost like PBMs love that because it almost seems like a pharmacy is continuing to mail prescriptions and then members are denying receiving them. And so it's like the picture that they love to otherwise paint to pharmacies when they're reviewing pharmacies for their network participation. Really interesting. I mean, there's so many it's definitely very aggressive of PBMs. And so when pharmacies receive those initial results, or even when they receive an audit request, it's really important to make sure they're providing that responsive documentation. It's really important to make sure they're going through the appeals process, that they exhaust all of that process, the appeal process when they receive final results, if the PBM allows for it, to further challenge administratively the final results, like through a separate like appeal process, or for a pharmacy to dispute those results as well.
So this is a topic that we deal with a lot, Harini. What types of disciplinary actions must be disclosed under the various provider agreements for these PBMs, and how should pharmacies confirm the who, what, when of disclosure?
Yeah. So audits aside, the other issue that we're seeing a lot of like pharmacies have issues with PBMs is over their failure to disclose disciplinary actions. And that is like a range of actions, right? It could be a board of pharmacy action, which you see a lot of, obviously, Eric, and you deal with, right? We see any instances of where there could be an employee excluded from Medicaid, or there could have been any sort of disciplinary action. There was even instances of where they may require disclosure when if there was a criminal action against a pharmacy owner as well. And so the each PBM or most PBMs have provisions that suggest that if there is a disciplinary action, which could extend again to an instance of where a pharmacy or even an employee was just placed on probation, and it's still in otherwise good standing. When those types of actions would need to be disclosed. And so each PBM has not only a definition of what they consider to be discipline, but also just like a method of making those notifications, and then a deadline for it as well. And I say deadline meaning, some PBMs say like, you need to tell us immediately. You need to tell us within 5 days, etc. So it's just like it just varies amongst the PBMs. But aside from, like I said, audits, like another thing is like the failure to disclose those disciplinary actions is certainly leading to a lot more pharmacies being hit with termination notices. And PBMs say, you failed to tell us about a board of pharmacy issue you had last year. We looked it up when you, or maybe for recredentialing, for example. And not only did you fail to disclose that, and we're terminating you on the failure to disclose, we're also going to terminate you because we don't think your conduct, meets our terms and conditions of our network. And so that's a big thing. And so if there's any pharmacies that really have ever had disciplinary action, is to make sure that they're reporting it timely, but then also that they're reporting out on any recredentialing or credentialing.
Right. And in addition to these disciplinary actions, there's something else called common associations, right, that need to be disclosed. And so what are, first of all, common associations?
Yeah.
Yeah.
Common associations, it's like there could be a couple things. It's common ownership and or affiliations/associations. That could extend to just like the actual owners of the pharmacy being in common. That could even extend to like the employees themselves, so whether it's someone in a managerial position more commonly. And I've even seen pharmacies, or I've seen PBMs extend common associations to even like a pharmacy technician, right? To suggest that pharmacies are associated with one another or have an affiliation because there's a commonality of employees and ownership, right? And so the failure to disclose those associations certainly can lead to a PBM otherwise terminating one pharmacy and then, of course, terminating the other for just a failure to report. And then, of course, if there was an action related to one, like over a termination of an audit, it certainly translates to any other pharmacies that have common ownership and or affiliations. So when we speak about all of these issues when it comes to PBMs, whether it's network actions against pharmacies for audits, for failure to report, or failure to report disciplinary actions, or failure to report common affiliations, or just anything else related to like the failure to comply with their terms and conditions, it's really important to challenge those adverse PBM actions, right? And so I guess one of the things that we'll kind of shift to is what do you do if this happens to you, right? And so I guess maybe Eric, just given that usually when we're handling this, we're leading up to the point of having to avoid further action. There's of course instances of where that happens, but before we get there, what information or what can a pharmacy usually expect when they receive a notice of termination?
Yeah, so and first of all, a notice of termination is just not a letter any pharmacy wants to receive, right? So when you get it, it can be shocking. But things you want to look at are right. You want to look at the basis for the termination. You want to say, why is this PBM terminating me? And some examples are they're going to allege that you committed some type of fraud. They're going to bring up the audit discrepancies or investigative discrepancies, whatever you want to call it, that Harini was mentioning before. So from the preliminary audit findings to the final audit findings, and then, okay, here's why we're terminating you. And sometimes it mirrors those final audit findings. There could be credentialing issues, could be failure to meet certain network requirements. The other information that I try to glean right away is what's the effective date for the termination? And this is important, especially as a lawyer, because I want to know the timeline, how fast we need to possibly challenge this, right? So hopefully we have something like 60 days, and working with Harini, can we try to get another bite at the apple with the in-house counsel over there at the PBM? Can we ask for some type of dispute resolution? Meaning, do we have time for this? Or do we have to ramp up for litigation? So the timing and how long do we have is very important. I also look at is the termination for cause, without cause, or is it immediate? Do we not even have any time? And sometimes these immediate terminations can come in the form of payment suspension or even claim suspension. You can't even submit a claim sometimes because they're alleging and we call that a de facto termination. So, if no money's coming in from this PBM, we have to act very quickly. So, from looking at the four corners of a termination notice, those are the things that I really focus on.
Do you feel like a lot of those notices, and I say this because a lot of the times when pharmacies receive this, they're like, what do we do? Do you
Yeah.
think a lot of those notices really give pharmacies any insights on how to appeal them or on how to address them versus just saying you're terminated?
Yeah, I mean, a lot of times it just says you're terminated. Here's why. Sometimes, there's a particular PBM that says you're terminated for cause and without cause. Okay. So here are the reasons, but that doesn't even matter because we can terminate you without cause according to our contract. And that's they're kind of talking out of both sides of their mouth there. But to answer your question very specifically, Harini, they expect you to understand either the provider manual, the provider agreement, wherever, depending on the PBM, where this particular information is located, and really for you to take the initiative to understand what your next steps are. And that's obviously where we take some pride to come in and step in and have that knowledge of each specific PBM.
Yeah, absolutely. And you mentioned for cause and without cause. We'll throw out immediate because we know that means immediate. But if you can just expand on like what for cause means and then without cause, because I
Sure,
think a lot of
yes.
folks get confused on that.
So for causes, we are terminating you because of X. All right. We're terminating you because of these particular discrepancies, or we're noticing a trend that signals some type of fraud, waste, and abuse. We have a reason why we're terminating you. Without cause is they're just saying, there's no reason. We could just terminate this contract whenever we'd like. And there's, most provider manuals, provider agreements will actually state that the PBM can terminate without cause as long as that it complies with applicable law. And it's important to have counsel for the reason where we can not only look at the contract but also apply laws there. And when they just say, we're terminating without cause, we don't have to provide you a reason. Well, the law doesn't make that so simple, especially if a particular state that you're in has an any willing provider law that's very favorable to pharmacies. It's super important to look at that law and see how it may apply to your contract.
Yeah, right. The any willing provider law is certainly important. And for any folks that are listening in, right, the any willing provider law essentially gives you the protections to suggest that if you are any willing provider, you should otherwise be allowed into that network or remain in the network for, I guess to super simplify it.
Oh.
And so I guess when we're talking about how to challenge those adverse PBM actions, when is an opportunity to be able to cure a notice of termination available? And then what does that look like? How does a pharmacy go ahead and try to address a notice of termination or any adverse PBM action?
Yeah, so Harini, you were talking earlier about, let's say, a clerical error. Let's say the pharmacist put down the wrong NDC number, or it was a digit off or something, the wrong quantity, something like that. PBMs may give you an opportunity to cure, have some type of corrective action plan. They sometimes they give 10 to 30 days depending on the PBM. And we've seen, pharmacies been afforded that. But like we were saying earlier, PBMs really gear towards the other side of the spectrum where they
Mhm.
will amplify a particular, let's call it error, and say that there may be an indication of fraud, waste, and abuse. But if you're given that opportunity, the PBM could ask to submit a corrective action plan. It was something that I know Harini and her team and my team as well. We will really look at what the PBM is claiming, look at it, pharmacy's policies, and help update those policies and ensure that when the corrective action plan is submitted, it's geared towards the eye of the PBM. We make sure that all staff have certified that they are been trained on the corrective action plan, and so that's an option. The only thing to consider is sometimes if you enter into a corrective action plan, the conditions of your contract could be even more strict than, let's say, the provider manual. But if you're given the opportunity, if a PBM will say, hey, you can remain in network for a corrective action plan, and depending on the situation, it may be something that you may want to consider entering
Yeah.
into.
Absolutely. And we've seen those, right? It's like three strikes of a small mistake and you're out on those corrective action plans, which are obviously much more aggressive than one of, the regular agreement. But when it comes to maybe like more, aside from like the cap aspect of it or like the opportunity to cure, when we're talking about just appealing and having the PBM reconsider their decision of terminating the pharmacy, what do pharmacies look to and like what's that timeline look like? What's the process look like for a pharmacy to be able to appeal that termination?
Yeah, you're looking at, anywhere from like 10 to 30 days, depending on the PBM. But really what you're doing is you're building off of, those preliminary audit findings, you've appealed those. Your final audit findings, you've appealed those. And you're submitting, if there is another set of documents that you might have located, really just, you want that one last appeal. Also, the contract with the PBM most likely requires you to submit some kind of final dispute notice. But before that, you're dealing with the audit findings, let's call them. But it may be necessary, if for you to actually engage in one final round of dispute resolution in
Mhm.
order for you to take that next step. So it's really important to understand those prerequisites in your contract.
Yeah, yeah, absolutely. And I know that there's certain PBMs that suggest that you get like a written appeal process, and then some PBMs say we will just engage in that dispute meeting instead, right? And so I'm sure it's certainly different. But how do you usually find PBM outcomes? Like when they come out with a decision, do you usually find those to be upheld? Like how final do you find that a decision is once a PBM makes it through like the business side?
I find it to be pretty final. Once a PBM has made up their mind that they're going to be terminating a pharmacy after those final audit findings, and then you get that termination notice, I found that, it does happen, especially, I've seen Harini do it. I've seen it happen, but I would say the vast majority of the time, if once a PBM's made up their mind, the termination has been difficult to reverse, in my experience.
Yeah, and I mean so much more of like once the pharmacy receives that final notice and then they go through that appeals process, right? That you find that there's benefit in that, certainly that appeals process, and then having that dispute process with the PBM, correct?
Oh, absolutely, yeah.
Yeah.
And yeah, and you must do it. And it makes you also, let's say you can't resolve it. There's also a narrative at the next stage that I deal with when you're dealing with an arbitrator or a judge, where you really want to show that you've made every effort to try to
Mhm.
resolve this. Not only do you want to avoid litigation, I totally get that. That's the best course from, a price standpoint, also from, you know, legal fee standpoint, also from, just the unpredictability of litigation at times. But yeah, no,
And when
I
you
think,
said
yeah,
something, Eric, not to cut you
yeah.
off, but you said something about like they have to do it. What do you mean by a pharmacy has to go through the dispute process?
Yeah, so what I'm saying is, according to the PBM contract, before you are able to, let's say, file in court or file a lawsuit against a PBM to challenge the termination, PBMs will require you, according to the contract, to go through these dispute resolution processes internally with the PBM. So that's when I say you have to, because let's say if you file without doing that, a PBM may be able to file some type of motion to dismiss, say, well, we shouldn't be here yet because they haven't done X, Y, and Z according to the contract.
Yep. Great. And I know that we see I know we see dispute resolutions as two different things. I like to see it as a secondary appeal as well for pharmacy to try to overcome that termination. And then of course, like you said, there's the contractual aspect, right, where they have to go through it anyway if they ever want to litigate or arbitrate, which kind of brings us to this, right, is that a pharmacy has exhausted all these administrative appeals process, and that's usually where we're helping pharmacies of trying to go through. And hopefully they're successful. But then if not, then of course, Eric, that's where you step in with your team is to be able to walk a pharmacy through an arbitration or litigation. And so a lot of the times, how does that process start? Why do some PBMs like prefer arbitration, right, over litigation? And what does that usually look like for a lot of pharmacies?
Yeah, so let's in the termination realm, so what we most likely will try to do is file, if the facts are to our favor, we'd most likely want to file a preliminary injunction to try to prevent the termination from occurring, right? And the way that we would do that is you file a complaint like you would in court, and you would detail the reasons why it's unlawful for the PBM to be terminating the pharmacy. And, this arbitration or litigation, like you're saying, why arbitration, just the difference, arbitration and litigation. Litigation is more of a term of art for court. PBMs tend to prefer arbitration because it's private. So their actions or the result will not be made public. And they don't want the public to know, let's say, for example, how many pharmacies may have been filing a arbitration against them. They also don't want to create bad case law if let's say a pharmacy um, wins in a particular matter. But I say that also there are PBMs that prefer court. They actually go the other route. And I think a lot of that is because there's one particular PBM that gets very favorable outcomes in their venue selection. But I think it's also a court in normal court is a lot more expensive and takes longer. And there's no limitation on, let's say, depositions or what we call discovery, the exchange of information. So they're able to, for lack of a better term, squish a small community pharmacy in legal fees, where this multi-billion-dollar corporation is able to, what's $500,000 in legal fees to them, and they use that as a tactic um, to their advantage. So there's different schools of thought depending on the PBM.
Yeah. What do you usually find that timeline process to look like, right? For a lot of
Yeah,
folks, whether it's arbitration or litigation, do you find them to be similar in terms of timeline?
yeah, not even close. So arbitration, I would say, is like 12 to 18 months, depending on the arbitrator or arbitrators and the panel. It's a lot more streamlined. So you're able to get a particular outcome much quicker. Court, oh man, depending on where you are, I'm talking years. It could be 2 to 3 years, something along those lines. And that's what I'm talking about. The different schools of thought is how long can a pharmacy sustain a certain litigation? So yeah, I find that arbitration can be a lot more beneficial from a cost standpoint, with the caveat that a private arbitrator is actually paid fees by the parties, which can increase costs, but I find it's nowhere near as close as when you file in court, the cost to the client.
Sure. Yeah. And so you talked about costs, and that's obviously a big factor in whether a pharmacy decides to pursue an arbitration or litigation, right? It's a huge cost benefit analysis for a pharmacy. And so obviously, like, how does fee shifting work into it? And then, when we talk about the strain on a pharmacy to sustain a litigation for 2 to 3 years, um, is there anything they can do to stay in the network while they're kind of throwing, like, while they're still in the course of this litigation or arbitration?
Yeah. So I threw that out there when I was talking a little earlier about a preliminary injunction, right? So
Yeah.
a preliminary injunction is an effective tool if the facts are in our favor, right? So what a preliminary injunction does is we're trying to file an arbitration or a lawsuit, but at the same time, we're trying to get a judge or arbitrator to keep the status quo. And when I say keep the status quo, to keep during the duration of the case, to keep a pharmacy within the particular network before a termination is actually takes effect. There are certain elements that we need to establish. One of the most important is the likelihood of success on the merits. Even at the beginning of the stage of this case, we have to show a judge or arbitrator that we're likely to succeed on the case. So it's very labor intensive, but it really gets our ducks in a row, and we really get to understand a case right away. If there's a particular inventory shortage allegation, let's say, and we have our records.
Mhm.
Let's say they weren't sent directly from one particular wholesaler, but the records are sound. um, you know, that's an example of, hey, we have the records here. It might have not come from the exact party and the exact timeline that the PBM wanted it to, but there's a likelihood of success that there's no breach of contract here. The other very important element here is irreparable harm, okay, in the absence of the injunction. Let's say the status quo is broken, the termination took effect. What kind of damages, what kind of irreparable harm will the pharmacy face without this particular PBM contract? And one thing that I look for, and it's probably the first question I ask a client when Harini refers a case to me, is how much of your total business is attributed to this particular PBM? Obviously, the larger the percentage, the better, right? So if, let's say, this PBM is 50% of your business, without it, you're going to be seriously harmed. You might even have to close your doors. You're going to have to lay off a lot of staff. Are you going to be able to pay the rent on your facility? Are you going to be able to purchase drugs? We get into the exact irreparable harm and how to present that. And the third element, which isn't as important as the other ones, are the balancing of the equities. Basically, if the pharmacy was to remain in network, who would it hurt more? Would the PBM be hurt more? Would the pharmacy be hurt more? And a typical argument that I make is, okay, the PBM will still have to monitor this pharmacy in their networks like they're doing now. Compare that to the irreparable harm that the pharmacy is going to face. So that's why I say that one kind of piggybacks off irreparable harm, in my opinion. So yeah.
Yeah, and typically, right, if a pharmacy gets a temporary restraining order or like an injunctive relief, does that mean that they can continue to stay in the network if and then as they go through the course of the arbitration or litigation? Because because I feel like a lot of people think, okay, I got my TRO granted, and then they don't think they have to go through the arbitration or litigation, right? Could you just kind of expand on that?
Yeah, sure. So once you get that preliminary injunction or temporary restraining order, whatever you want to call it, it's that first major hurdle. And when you get it, you do have the momentum in your case. Okay, you're going to remain in network. It may make the PBM reconsider the case, but let's say they say, great, let's go forward. You're going to have to go forward through the whole arbitration to get what's called a permanent injunction. Um, you know, but the beauty of this preliminary injunction is we've done a lot of the legwork up front, but there's still going to be discovery exchanged.
Yeah.
A lot of it will be duplicative of what Harini and her team would have done in the final audit stage, the appeal of the termination stage. But there's also going to be depositions to prepare for, and then ultimately a final hearing that we need to prepare for. But hopefully, once you get the preliminary injunction, and I've seen this happen, a PBM may reconsider their decision to terminate.
Meaning that they may come to the table and discuss settlement, correct?
Exactly. And
So,
that settlement from our end would need to state that the pharmacy stays in network, foremost and most importantly.
right. Just not being doomsday here is suggesting that we never settle.
No, no.
Since you're just kind of coming off of the discussion of some of the arbitration talk and how pharmacies can pursue TRLs, maybe if you can just walk us through, like, really quickly, an example of an instance of where a pharmacy had that you've dealt with a pharmacy that's kind of had to go through that process.
Yeah, so but the example I picked was, a kind of a client that was like near and dear to my heart, I must say. They're a family-owned pharmacy for generations, and they're definitely like a community-based pharmacy, true and true to that term. So there's a major PBM, all right, and they alleged inventory shortages separately, but they alleged purchases made from non-NAP accredited wholesalers, and they also alleged that the pharmacy wasn't reversing claims that were dispensed within 14 days of the of of dispensing. So, um, but they were terminated strictly for the inventory shortages. All right. But the PBM clawed back like $350,000 from this particular pharmacy, which is obviously devastating. And this particular PBM was, if I remember correctly, it was around 70% of their business. Without this contract, they were certainly going to have to close. Decades of building their business, but also supporting their community, would all have gone out the window. So,
Mhm.
we what we did was we agreed, you know, PBM team, Harini side, they offered a corrective action plan early on, and we didn't really shy away from there being some discrepancies there. You know, we said that there were inventory shortages there due to, let's call it, record keeping. There were, it had nothing to do with purchases. There were no, we really highlighted that there were no patients who ever complained or
Mhm.
had any type of complaints that they never received their medications, which I think is huge in the inventory shortage situation. I mean, these inventory shortage allegations are for like the worst kinds of fraud. Like we don't have this inventory. These are fake patients, and these are fake claims. We don't even have the inventory for it, but none of that could be substantiated by the PBM. So um, we were able to file that preliminary injunction, and we were awarded that. I think we showed that, hey, the pharmacy is doing everything in their power to comply with this contract. Minor clerical errors have been fixed, and they won't occur again. Here's why: they updated their computer software. Everything previously at this pharmacy was done in like notebooks kept by hand. Everything was now documented by computers. We really showed that, okay, these errors will not occur in the future. And luckily, this arbitration kind of flew by pretty fast and is about a year long, which is on the shorter side. And I think
Mhm.
we were really able to show that this pharmacy not only didn't commit any fraud, waste, and abuse, but they are dedicated to actually updating their policies, which is hard for a family-owned pharmacy that's been operating for decades. So that's just one of the success stories I wanted to highlight.
Yeah, and it's great that they were still able to continue participating in the network because you're able to get them that TRO right as you kind of continue the dialogue with the PBM as well. So that's really great. And it's not an instance of where every discrepancy that a pharmacy is able to overcome every discrepancy, right? But we're able to sort of navigate how we address those with the PBM for sure, whether it's through the appeal process, dispute process, or through, further action as
It
well.
does the penalty fit the crime? All
Right.
right.
It's the biggest thing.
Like should this pharmacy be shut down? Should not be able to serve its patients ever again for these
Yeah.
particular errors?
Yeah. Is a breach so material enough for this to otherwise justify a termination from the pharmacy? Um, and similarly, right, one of the other examples that we had and that we've worked through on our team is certainly when it comes to very similarly inventory shortages and having audit results related to those. And the reason that we took the same kind of issue of like purchases from non-NABP accredited wholesalers is because different PBMs have different perspectives on sort of how they treat pharmacies, and then also the same PBM could treat two similarly situated pharmacies in two very different ways. And so, in the instance that Eric mentioned, where the pharmacy wasn't successful through the appeal and the dispute process, had no choice but to consider pursuing action through an arbitration, we were able to overcome another pharmacy's termination based in New York, same community pharmacy, independent retail pharmacies, termination from a PBM over very similar issues. It was a $150,000 chargeback for purchases from non-NABP accredited wholesalers, including pharmacy marketplaces. And so not only was the pharmacy being subject to that chargeback, they were also being terminated over it. And so we not only went through the appeals process, we also ended up having to go through the dispute resolution process, which allowed us to have a productive discussion with the PBM, which surprisingly does happen very often, and have a discussion of how the pharmacy should otherwise remain in network, the chargeback wasn't justified, et cetera. And so ultimately, we were able to reverse the termination of the pharmacy, of course, conditioned on the development of and implementation of certain corrective action measures. Because yes, ultimately, at the end of the day, the pharmacy did purchase from non-NABP accredited wholesalers where they're otherwise required to do so. But we were able to demonstrate successfully that it shouldn't have led to the termination of the pharmacy. And so the appeals process and the dispute process is certainly really important for a pharmacy to take advantage of. And then, of course, if those aren't successful, in which case, hopefully they very much are, you always have the ability to still consider pursuing further action through an arbitration litigation, depending on the PBM.
So, thank you so much for everyone for joining us. We hope you found our discussion insightful, valuable, and have a great day. Thanks again.
Thanks, everyone.